Hi, so my name's Simon Flacks from the University of Sussex, and I'm here with Helen Stalford and Professors Helen Stalford and Kathryn Hollingsworth, who won the Best Article Prize for the SLSA in 2021 for their excellent article, "This Case is About You and Your Future Towards Judgments for Children," which was published in the Modern Law Review in 2020. So first of all, congratulations, both of you, for writing such a fantastic article. And I thought I'd begin by just asking what your motivation was really for writing it.
Shall I kick off, Helen?
Sure.
Well, Helen and I were the co-directors of the Children's Rights Judgments Project, which was one of the judgment rewriting methodology projects. And I think we published that book in 2017, I think. And as part of that project, so we had about 60 contributors who were all looking at judgments from across the world and what makes a judgment a children's rights judgment. How can existing legal judgments be written in a way that's more compatible with children's rights laws, processes, and so on. And theory. And so as part of that, Helen and I wrote one of the introductory chapters, we identified 5 characteristics of a children's rights judgment. And the 5th of those was communicating the judgment to children themselves. So how judgments can be written in a child-sensitive way for children as the primary audience. And a couple of the contributors had attempted to do that in the collection. And then around the same time, Peter Jackson, now in the Court of Appeal, had written a decision, a judgment written in the form of a letter for a child in a family case. I suppose both of those things had kind of prompted Helen and I to think much more deeply, I think, about why it's important for judges to communicate directly with children through their judgments, and what the justifications are for doing so, and what can be achieved, what the functions are of a judgment. And that hadn't really been in any academic literature before, and actually there isn't there's very little, isn't there, in terms of even in the sort of children's rights legal framework. You know, we have shifts towards more child-friendly justice, but actually on the judicial communication to the child, it doesn't go much further than, you know, the child should be able to understand the outcome. So it's not even about the judgment. A lot of it's just understanding the outcome of the proceedings. So that was kind of where our interest came from, was to explore this more deeply. Helen, I don't know if I've missed things there.
Yeah, no, I think the Peter Jackson judgment kind of took the legal world by storm a bit. It was surprising, because it was a pretty bog standard family law judgment about whether a child should be allowed to relocate with his dad, and how the judge, in deciding that he shouldn't be allowed to relocate, should communicate that to the child. And it was done in a really sort of sensitive, clear way, and really kind of unpacking what were the problems with him going with his dad, and how his dad might have effectively sort of manipulated him a bit. But it was done in a really sort of effective way, and that seemed to really capture the minds of the legal practitioners. And we just kind of launched on this a little bit, and started to think beyond just the kind of communicative value of the judgment, and start thinking more about the other functions of judgments, and not simply with a view to looking at children's access to justice, but also how other vulnerable people, or indeed how anybody, really engages with judgments. And I guess the wisdom being that if you can do things right for children, you can generally do it right for anybody else, including adults. So it had broader importance for us beyond just judgments for children.
And have you had much kind of response to the article from practitioners or magistrates or judges or organisations?
Yeah, I mean, I guess we've been trying quite a lot to try to influence how judges might think about communicating. I mean, with the Children's Rights Judgments projects, we had did quite a bit of dissemination with that. We went to Dublin, didn't we, to one of the Children's Rights Congress, World Congress conferences, and there's a lot of judges and practitioners there and from across the world, and we're quite lucky because Lady Hale did the plenary there, and she based it really on the project, and that sort of generated interest in our session, and that generated interest we had some Canadian judges and Singapore judges, and Helen did some training in Scotland. I was going to New Zealand, so we did some dissemination over there, and so it was at that point, even it was kind of this part of the research that was of interest to most of interest to judges, I suppose. So we've tried to build on that side of things, particularly with the judiciary, and yeah, we have had some success, I think, in the because we wrote the article across legal discipline, across legal context, so family law, but also it was generally written to apply also in, say, immigration or in sentencing. So I think we've had I've been doing some training in the Crown Court judges and have been involved in amending some guidance for Crown Court judges on sentencing and sentencing children, and we've got a specific appendix in some guidance on how to do that tries to capture a lot of what we wrote about in the article, and also includes exemplar sentences, how to communicate them effectively to children. So that, it's hard to know how many judges, how they're putting it into practice unless they tell you. But it seems to be received well, I think, by the judges who are probably already quite wanting to do things differently and are thinking about children differently, perhaps. I don't know, Helen, from the immigration context.
So we had during the writing of it all, just before it was published, I guess, we had an immigration judge who took a real interest, first tier tribunal judge, and so she actually had a go at drafting one of her refusal decisions. So a really difficult decision for a child who wanted to have refugee status in the UK. She drafted it in a child-friendly way, I guess. And she said, and one of the things that we say as one of the kind of functions of a child-focused judgment is that it should have a transformative effect on the way that the legal process is run. Because if you look at that through the lens of how you're going to communicate that to the child, then the actual process that leads up to that decision should also be children's rights focused as well. You can't just kind of bolt a child-focused judgment or a child rights-focused judgment onto the end of something that is completely antithetical to that. So she started kind of drafting her judgment in that way. She said it really changed the way that she approached the whole kind of process, really. So that was one kind of interesting example, although it was just an isolated example. But I did some training with the Abu Dhabi judicial kind of academy, if you like, before last December. There was about 90 of those Abu Dhabi judges, and it was mostly about children's rights judgments project more broadly, but they were particularly interested in judgments for children. And we deliberately moved away from the language of child-friendly judgments, because many judgments are not that child-friendly. They're harsh, they're difficult realities to grapple with, and really looked at as about being justice for children and judgments for children, warts and all, if you like. So they all wanted to then embrace judgments for children as a modus operandi in Abu Dhabi. So that was quite a significant step for them, and they've asked to translate the book of children's rights judgments, and they've asked to translate the article and to do some further training on the back of that. So the international reach of it, people are really engaging at all levels, and in all judicial contexts with this idea of communicating their judgments to children.
And it's so powerful when you see it. Like there was so in the sentencing context, one of the judges who we worked with in the the guidance, and who is a Crown Court judge, wrote his sentencing remarks in it. It was a manslaughter case, so it was a diminished responsibility. So a 14-year-old girl who was charged was pleading the defence of diminished responsibility, and he wrote this really powerful sentencing remarks. So he explains, he's going to do a version for her, and then he'll do a version for the lawyers. And I think what's very powerful about it, it's not just that the language, and this is one of the things we really wanted to focus on in the article, wasn't it, Helen? It's not just the clarity of the communication, but the relational element and the showing empathy and showing care. And when this particular judge's decision, which actually was appealed at the Crown Court for leniency, but unsuccessfully, and the Crown Court commended how he'd done a version for the child and for the wider audience, if you like. But it was incredibly moving, like when he's reflecting back, and this is one of the things we talk about in the article, about the importance of the judge reflecting back to the child their own experiences. Important for the reason, as Helen said, about the legally transformative, because it ensures that the participation is there. If you're going to reflect back to the child that they have been heard, you need to hear them in the first place, and you need to give due weight to those views. And obviously in sentencing it's quite different, but just reflecting back that what she has gone through in her life and the harm that she has experienced, and that he sees that she has a good heart even though this thing has happened, and he hopes, and he talks about, if she wants to write to him when she's in prison, he'd be pleased to hear from her, and really building that relationship. And I've done some interviews with justice experienced children, criminal justice experienced children, and about their experience of sentencing, and part of that is asking them I read to them different examples of sentencing remarks, one of which was written by the chair of the magistrates, ex-chair of the Magistrates Association, to capture all the principles that we put forward in the article. And when the young people read this, I'm still quoting the data because anyway, it's taken a long time. The interviews took a long time because COVID broke them up, but it's so powerful when how the young people respond to that set of sentencing remarks. And they talk so much about how important it is that the judge is showing that the judge cares about them, and the recognition function, it's being seen, and being seen as an individual child, but also being seen as a child, as part of a social group of children who deserve special treatment, I guess, and consideration. So it has been, it's been such a satisfying, it's been so, professionally and personally important, I think. I don't know, I both writing with Helen and the academic side of that, but also how it has been picked up, and in these sort of things, that examples, I guess. Like
one of the recent conversations that I had was with a judge in the European Court of Human Rights and who deals with a lot of children's cases, and I talked to her about the article and about the project, and she was really interested in how they could translate that into an ECHR kind of level. And for a court that is kind of a human rights court to not really have grappled with how they communicate decisions to children who are barely ever heard in the European Court of Human Rights, then I think they're really interested in sort of exploring that more. So I think that was the nice thing about the project. It feels quite timeless in that way. A lot of, especially legal articles that you write, they have a limited kind of shelf life, and the ideas can quite quickly date. But this feels like it's got quite a long shelf life as an idea. So I think that's what's one of the most gratifying things, is that we stumbled on something. I say stumbled on it, but we thought we carefully planned something that actually seems such a no-brainer, doesn't it? Yeah. And we've got such an abundance of work on children's participation in the justice process at different levels, but virtually nothing on the most important part of that process, which is the decision.
But that's really important, though, isn't it? But you did identify something really important, which was the distinction between child friendliness, which is in some sense sort of tokenistic, right? When we think of or potentially tokenistic, and reframing that as judgments for children, where it's really about Would you describe the distinction as that, where it's more about actually not just, I think Kathryn, you said just about language, but about really recognising children as important participants and active participants in the process?
As legal citizens, we talk about these 4 functions of a judgment for children. The first is to communicate the judgment to that child so that they can understand it, that they can reconcile themselves with it, you know, that they can have the information that they need to decide whether to have an appeal or all sorts of things. So there's that communicative function, which I think most people would sort of stay with. You know, how clear is that judgment? And, you know, let's just put it in kind of softer language or a simpler language. But then beyond that, we talk about this developmental function. And as Kathryn said, that, you know, the actual process of communicating what might be a really painful decision about, you know, stripping that child's life bare and scrutinizing it intensely in what can be an intensely public forum as well. That has implications, and we bear a responsibility towards that child in how we conduct that process, for good and for bad, really. And then the third is the kind of instructive function, that this isn't just about that individual child in that individual case. There are really key landmark cases where it has an important impact, a precedential kind of impact on children's rights more broadly. And we use amongst some of the examples, but we use the example of the Gillick case, that landmark sort of judgment that has, at the time, completely changed the face of children's rights, albeit, you know, we can have a separate discussion about that. But I've been looking at that more recently in the context of the COVID vaccination and parents' opposition to their children having the COVID vaccination. Now, if children had been educated properly around the implications of Gillick, beyond just the access to contraceptive advice and abortion, everyone would know that for 40 years plus, we've had the right for children to go and seek any kind of medical treatment, or indeed make any decisions that shouldn't be age contingent. And so children should quite rightfully just be informed about their access to a COVID vaccination or any vaccination. And we shouldn't be insisting on parental consent if that child is deemed to have the capacity and it's in their best interest to do it. Now, that's a really good example of how a judgment like that has an enormous instructive value that can kind of be passed down through the generations, if you like. So that was the third value, and then the fourth was this legally transformative value, that it impacts upon the whole process and the way the judge views that process and their own responsibility.
Yeah, and just linking back to the Gillick case, that legally transformative process as well, and the point that we make about those complex concepts, that if a judge is writing for the child, they have to simplify them, so they can't obscure the decision making by just making some reference to this was Helen's point, I remember her. What the public interest is, or what best interest is. If they're going to explain it to the child, they're going to have to unpack that, and that in itself can then affect how the judge is making the decision, because they can't, it's going to lead to greater transparency, really.
Fascinating. And I mean, I feel like I could talk to you for hours about the substance of the article, but I was also wondering what, having written a prize-winning article in the Modern Law Review, if you have any advice for early career researchers, or, well, even not early career researchers, on the kind of important elements you think of of creating such an influential and important piece of work.
I think find somebody, if you're going to co-author, find somebody who you like very much, but who, I think Helen and I think I speak for Helen, we both really enjoy working together, and we complement each other very well, I think, in different regards. And so I always find it a great pleasure to work with Helen. And so when you come up with an idea together, and then you start to explore it, the yeah, you can bring your strengths, I suppose, to that piece. But I think for this piece, I think there was a clear area, the originality, I think was there, because it wasn't something that had been thought about or considered before. And then there was a real depth of research, I suppose. It doesn't always come out in the final piece, does it? You have to strip back a lot, but I suppose that helped develop a certain confidence for us when we were writing it. Maybe, I don't know, that we were, we felt quite sure about what we were writing. And then I think, the clear communication, and this is, Helen's real strength there, is kind of, I think coming up with, like, having 4 clear messages, 4 clear functions, as we call them in the article. I think that kind of level of messaging really helps, I think.
Yeah, I mean, I think we had the luxury of working together. We love working together. I love working with Kath, but I think for me, I mean, I'm not an early career researcher. I've been doing it for ages, but I think it was one of the most rewarding experiences, and that's because we give ourselves the license, if you like, to take our time.
It takes time, absolutely, absolutely.
So it took us about 18 months, really, but we were thinking about it even before then. So in total, you could say we were thinking about it from the time we were doing children's rights judgments back in 2017, and that actually started in 2015. So to give ourselves that time to just explore those different avenues. I mean, Kath is really good at theory and I'm terrible at theory. And so just recognizing your limitations, but also where your strengths are, and really playing to those and not trying to be something that you're not. I think if you can find a really good co-author, that's brilliant, because you can sort of bounce off each other. But if you can't do that, then it's sort of navigating that fine line between, just having the confidence to kind of explore, get yourself out of your comfort zone, kind of academically, intellectually, or whatever, but also knowing that you've got something really valid and important to say, and playing on your strengths. The other thing I would say, just in practical terms, is that we kind of workshopped our ideas. I did a workshop here in Liverpool as part of our staff seminar series. That was enormously helpful for me, because it enabled us to get out of our little echo chamber to people who weren't a children's rights audience, to put it in front of people who were kind of constitutional lawyers or private lawyers or international lawyers, and to see if it really passed muster with them. And I think that's what has been one of the successful features of this particular article, is that it's got a really broad appeal and a broad audience, because everyone kind of understands what judgment is and should be.
Yeah.
Brilliant. Excellent advice. Well, thank you very much again for taking the time, and congratulations very much on winning the Best Article Prize. Thanks for talking to us.
Simon.
Thanks, Simon.